Shall I admit Simon?
Yes, please.
Are you recording? Oh, it is recording. Yeah.
Right, okay.
Okay.
Guys, do you want to mute yourselves?
Yeah.
Okay. Right. Hi guys, good afternoon. Thank you so much for joining us for this really fantastic session that we're going to have with the spectacular Steve Broach.
No pressure.
If you're not too sure about the session, it's actually Steve's going to talk us through the temporary legislative changes that have been implemented as a result of COVID. And I'm not going to say too much, but if you do want to ask Steve a question, you can by all means use the chat platform on the it's either on the right hand side of your screen or certainly the chat bottom at the bottom. So please feel free to ask any questions or clarification. I do need to remind you all that if it is a personal question and it's personal to you and your family, unfortunately Steve can't take personal responses. So please can they be general questions? And I'm sure that he'll be able to answer those for you. Okay, so I'm absolutely delighted to have Steve here. So I'm going to hand over to you now, Steve.
Thanks very much. That's great. Thank you very much, everyone, for joining me this afternoon. I think it's always particularly impressive when people choose to join a legal session on a Friday afternoon. It must mean that you're particularly keen to get to grips with what the law means in our area. So I'm going to be focusing on children's issues today. Thank you for the thumbs up, Caroline. And then on Monday, looking at issues for young people aged 18 to 25. And of course, there will be a significant overlap in what I say in the two talks, but today is very much going to be focused on those aged 0 to 18. Just to introduce myself, I'm a barrister. I practice at 39 Essex Chambers. Debbie, getting some water delivered by my boy. Thank you very much. And I focus on the law involving disabled children and young people, always have, partly because before I became a barrister, I worked in the voluntary sector for the National Autistic Society, Treehouse, which is now ambitious about autism, and most recently the Council for Disabled Children. So I have a long background in policy around disability children's issues, not just the law, and hopefully that gives me a bit more of an understanding of what matters to families and what the reality is for many families, as opposed to what the law says. Not always the same thing, sadly. And I was very involved in the Aiming High for Disabled Children programme, which led to the funding for parent forums that thankfully we still have. And it's fantastic that the forum is still going and that it's going strong and the parents are coming together to understand their rights and to share this information. I'm really pleased to see so many people here today. I have got some slides, which can also be shared by email later if that's helpful. I'm going to now share my screen. Hopefully this will work. You should see my Google page, and then hopefully my slides are about to appear. Very good. And I'll talk to these. And obviously, one of the things I've been asked to focus on today is the changes to the law brought about as a result of the current public health emergency. But before I can do that, I need to make sure everyone's on the same page as to what the law is and was. And most of the law that we are concerned with for disabled children hasn't been changed under the Coronavirus Act or under any other new regulations. So much of the talk that I can give today is the same as a talk I would have given in March, for example. Nothing radically has changed, apart from in relation to the HC plans, which I'll come to a little bit later on. But before we get to that, I must start by explaining what the law is. Now, apologies if anyone's heard me speak before, because this slide doesn't ever change. But I do need to start with the basics, because there is often confusion, I think, between what law is and what is policy. Policy is something that's very important in local areas, influenced by local authorities or clinical commissioning groups for the NHS now. But it's not the same thing as the law. So where do we get the law from? First of all, we get it from acts of parliament. For example, the Children Act 1989 or the Children and Families Act 2014. And whatever Parliament says the law is the law. There's a key difference when Parliament creates law that affects public bodies between the powers and the duties the law creates. And that's particularly important in the period we've had for some time now of austerity and cuts to public funding, where local authorities are struggling to do more than the minimum. Perhaps when I was working in the voluntary sector in the 2000s, the law wasn't quite as important because most local areas were trying to go beyond the basic requirements. But for the last 10 years, I'd suggest it's been a struggle for most local authorities to manage to meet the basic requirements of the law. And those are their duties. A duty is when Parliament uses the word must or shall in legislation, because that's mandatory language. It has to be done. Whereas if Parliament uses the word may, that creates a power and that allows something to happen, but doesn't require it to happen. So you need to understand, if you're looking at a piece of legislation, if you look at what you're looking for is the words must and shall. It's mandatory language that creates duties to do things. If there's only a power to do something, the word may has been used by Parliament, then the public body has to think about doing it, has to consider doing it. They can't fetter their discretion and refuse to even allow it to cross their minds that they might do the thing, but they don't have to do it. So that distinction is absolutely key. And we also find powers and duties created in secondary legislation, regulations, for example, like most notably in our area, the SCN and disability regulations, which set out all the various timescales and processes in more detail to do with EHC plans. Now, those regulations have been significantly amended for the period of coronavirus until the 25th of September, in fact, in terms of changing the timescales, but I'll come on to that in a little while. But they're an example of this kind of secondary legislation, which is actually made by government ministers, by the Secretary of State for the relevant area, and it's approved by Parliament and it's made under the Act of Parliament. So it's law just as much as the Act of Parliament itself. So when the regulations in normal times say that the EHC plan, the process must be completed within 20 weeks, that's not a target or an objective, that's a duty, must be done. And not to do it within 20 weeks, unless one of the three very limited exceptions apply, is unlawful, just the same way as if that obligation was in the Act of Parliament itself. And then we also have things like rules and directions and orders, which are other types of secondary legislation governing, for example, the way in which court proceedings might happen. So all of that is legislation at 1A, B, and C. We live in a common law system, though, and in the common law legal systems, like England and Wales, the case law is very important because the judges, as well as interpreting and deciding what Parliament meant when it passes legislation, can also lay down rules themselves, which are supposed to reflect the standards of our society. So, for example, all of the law around what it means to consult fairly comes from the judges. All the principles of fair consultation, that it has to be done at a sufficiently early stage, there has to be enough time for people to respond, they have to have enough information to respond properly, and so on. That all comes from case law. And so the judgments of the High Court, the Court of Appeal, and the Supreme Court all set a precedent, and that means they bind lower courts and are highly persuasive at their own level. We also, of course, in our area, have a tribunal that's very important, the SCN and Disability Tribunal. The decisions of the first tier tribunal, the old SENDIST, don't set a precedent. They don't legally matter to anyone except the people who were directly involved. But the upper tribunal, where appeals go, those judgments, those decisions do set precedent. They have the same status as the decision of the High Court. And so I try and write those up, and also the other key judgments in the ordinary courts, in a series of case law updates for the Council for Disabled Children, which you'll find on the CDC website. I think we're up to 40 now, summaries of recent important decisions. And I can't believe I've got this far and I haven't plugged my book. That's outrageous. And all the law, of course, will be found in here, Disabled Children, a Legal Handbook, which is the text that I work on with Luke Clements and a whole load of other lawyers. And the third edition came out at the beginning of this year. And you can download all the chapters free of charge from the Council for Disabled Children website. And you can also get the hard copy and the ebook, which is great because it's really searchable, from our publishers Legal Action Group from their website too. So if you're wondering, where do we find all these judgments? Where do we find all this precedent that's been set? The answer is hopefully in our book. And we've also, in chapter 2 of the book, set out some of these key common law principles, for example, around fair consultation, or what does it mean for a decision to be irrational? All of that is dealt with in chapter 2 of the book. So in our system, in the common law countries, the law is essentially the legislation that's created by Parliament or under Acts of Parliament, and then the case law that builds up from the higher courts. We also have, of course, in our area, lots and lots of guidance. And some of that guidance is statutory guidance, which means that it is itself issued under an Act of Parliament. So, for example, working together to safeguard children, the key guidance on children's social care, that is statutory, and the duty on local authorities in relation to that guidance is to act under it. And that means that they have to follow it unless they take a considered decision, but there's good reason not to do so, which in my experience, no local authority has ever done. So that guidance is as close to law as it gets, because in principle, a local authority could refuse to follow it, but they never do. Other kinds of statutory guidance, though, is weaker, and usually the duty that's imposed by the legislation is to have regard to the guidance. So, for example, in our area, the SEN and Disability Code of Practice, that's have regard guidance. The local authority, the tribunal, and other bodies have to consider it, but they don't necessarily have to follow it if they choose not to do so for good reason. The Code of Practice, though, is full of the word must in bold, and the reason for that is that in those cases where that term is used, the civil servants are telling us what they think the law requires, but they might be wrong. They are occasionally. For example, some of the guidance on school transport in the Code of Practice has been held to be wrong by the upper tribunal. So don't rely too heavily on the Code of Practice. If you can, just search for the law itself. If you want to know what the SEN and disability regulations say about the contents of EHC plans, look in Regulation 12, I think it is, from memory. And you can find them on Google. And what you're looking for is the legislation.gov.uk website, which is the official source of the law. Or, of course, you can look in our book. As well as statutory guidance, there's a whole raft of non-statutory guidance, which might be described as practice guidance or advice or best practice guidance and so on. Now, most of the time, it's up to the public body whether they want to consider that or not. But in some cases, it will be so obviously relevant that it would be irrational for them not to consider it. And I suggest an example of that is the National Framework for Children and Young People's Continuing Care, which rather bizarrely is non-statutory guidance. But again, I've never known a clinical commissioning group try to argue that they don't have to at least consider it. And in most cases, they would accept that they have to follow it. But in any case, guidance is never law. And law is always more important, not just than guidance, but also importantly than local policy. And any local policy that a public body adopts must be consistent with and must promote their legal powers and duties. So that's your very quick run through of where we get all this law from that I'm going to be talking about today. If anyone has any questions about that, I'll just pause for a moment, see if anything's come through on the chat. Do feel free to ask, even though I've moved on to the next slide, because I appreciate we're going to be going at quite a pace this afternoon. One of the advantages, of course, of the webinar being recorded is that if you need to, you can watch it back later on. The next intro slide talks about judicial review, because all of this, I hope, would be very interesting generally. But if you couldn't make it real, what would be the point of having all this law that I'm about to go on to talk about? And the reason it does have a relevance is that in most cases, public bodies can be held to account through judicial review. Judicial review is always available against a public body, but it's supposed to be the remedy of last resort. And so if there is something else you can do, like, for example, go to the tribunal, that's what you're expected to do. So how does judicial review work? It's a process of review, as the name suggests, by a High Court judge who'll be looking at whether the decision that the public body's taken or the policy they've adopted is lawful. And that means they're not looking at whether it's right. It's not about the merits of the decision. It's about, was this a decision or a policy that the public body were lawfully allowed to make, and have they made it in a lawful way? And so generally the focus will be on the process, and have they consulted the right people at the right time? Have they thought about relevant things? Have they ignored all the irrelevant things, and so on? If you're not attacking the process, then what you're normally trying to say is that in substance, the decision or the policy was either unreasonable, which in short means that no reasonable decision maker would have thought that was a decision that they should take. So it's a pretty high bar. It's got to be outside the range of reasonable decision. Or increasingly, we look at the proportionality of decisions. When we're challenging things under the Human Rights Act or the Equality Act, very often the question is whether the impact is proportionate. And in essence, what proportionality looks at is whether there's a fair balance between the rights of the individual and the wider interest of any other groups. And that concept of fair balance is at the heart of proportionality review. So you can challenge the substance, you can challenge the outcome, but very often, as well, or perhaps exclusively, you'll be challenging the process by which decisions are adopted. Because the court is not competent and is not willing to engage in a debate about the merits of any particular decision. You can't go to court and say, I've been given 8 hours care and I think we should get 16 hours care. You'd have to go to court and say, I've been given 8 hours care and that is an unreasonable decision, or perhaps it's a disproportionate one in the circumstances of our case. What do you get if you go to court for judicial review? Normally you would get what's called a quashing order, which is where the court will set aside, will quash the decision that's been taken. It will be as if it never happened. You can sometimes get a mandatory order requiring something to be done, but that will only be where there's only one lawful outcome, because the court doesn't want to tread on the toes of the public body. And a very important point at the end here, judicial review is an expensive process in the High Court, and it's not something that I would ever suggest anyone should consider doing on their own without specialist lawyers. And so you need to be able to fund not only your own legal costs, but more importantly, the other side's legal costs in the event that you lose, because in our system, the general rule is that whoever loses pays both sides' bills. And in order to avoid having to face those very high costs, generally the way out of that is to get legal aid, which may be available in the child's name. And so most of the cases I'll talk about today, and most of the cases I'm instructing on, are funded through legal aid. If you can't get legal aid, increasingly people are using the website Crowd Justice to fundraise from concerned individuals, giving donations. There are other mechanisms. There's a principle of what's called cost capping orders that can be used to limit the amount you have to pay to the other side if you lose. All worth considering, but the starting point would always be, can we bring this claim using legal aid? And in order to get legal aid or to get any claim off the ground, you're going to need a specialist solicitor to help you. And on my blog, Rights in Reality, there is a list of the solicitors that I've worked with in our area, which you may want to contact. So it's Rights in Reality as one word, and then solicitors gives you that list. I'm not saying it's a complete list at all, but it will be a starting point for people that you may want to get in touch with if you feel that there's an issue that may need judicial review or other kind of legal intervention. But do bear in mind 2 things. First of all, judicial review is supposed to be the remedy of last resort. So it's very important, of course, that you've asked first. You shouldn't come straight to lawyers. You should try and sort things out to a limited extent, at least, yourself. But it's also a remedy that has to be brought promptly and no later than 3 months after the decision that you're challenging or the policy that you're challenging was adopted. You can get that time extended, but it's difficult. So you do need to get advice as soon as possible once it's clear that you have a legal dispute. And I've never known families take that advice too early, but I have sadly known many take it too late. So it's very important that people do seek advice promptly, whether from one of the solicitors on my blog or otherwise. Okay, not having any questions yet through on the chat, that's fine. I presume then that people are happy with my outline of the legal background, including judicial review as a remedy. I'm now going to plough straight in to what I think might arguably be the most important slide in the whole talk, because very often in my experience, the problems that disabled children face are, the legal remedy is going to be discrimination under the Equality Act. The legal issue is discrimination. And there are various different types of discrimination that are prohibited under the Equality Act in relation to disabled children. And disability is one of the protected characteristics, of course, along with sex and race and so on. And the first type, the most obvious type, is direct discrimination, which is where you are treated less favourably because you are a disabled child, in our example. You must leave this shop because I don't like autistic children, they cause trouble. Hopefully that's relatively rare. What we will see much more frequently is indirect discrimination, where there's a policy or a practice which indirectly impacts on a particular group much more than on the rest of society, for example. So there's a disproportionate adverse effect on one particular group. Let me try and give an example of that. Schools that operate a zero tolerance policy in relation to behaviour. The school has a genuine zero tolerance policy, no exceptions, bad behaviour automatically results in a sanction. In my view, that will be likely to indirectly discriminate against disabled children. It doesn't directly discriminate against them because it applies to everyone in the same way. But the impact on children with autism, for example, is going to be so much greater because they will struggle to manage their behaviour as a result of the inaccessible environment they're in. And therefore, the school will have to justify that indirect discrimination in order to avoid it being unlawful. They will have to show that the policy is a proportionate means of achieving a legitimate aim. And they'll say, well, the legitimate aim is behaviour, improving behaviour, and that's fine, we'd accept that. But the real question is it proportionate? Does it strike a fair balance to have a rule like that? And my view is it wouldn't, because it wouldn't be proportionate, because there'll be a more nuanced and a more subtle way to have a policy that still promotes good behaviour, but recognises that for some children there will be issues managing their behaviour that may not be any fault of their own. So that's the concept of indirect discrimination. Much more likely, much more relevant, I think, than direct discrimination nowadays. And what you're looking for in terms of possible indirect discrimination is blanket policies, rules that apply to everyone without any or without enough flexibility or exceptions to take into account the needs of our children. So then the third type of prohibited conduct under the Equality Act is discrimination arising from disability. And this is where someone's treated less favourably because of something arising in consequence of their disability, i.e., for example, the way they behave. So if you've got a child who's got Tourette's syndrome and they are stimming in a particular place, say in a shop, and they're asked to leave because it's putting off the customers, that wouldn't necessarily be direct discrimination, but it may well be discrimination arising from disability because the less favourable treatment is linked to the behaviour which arises from the disability. And that, again, can be justified if what's being done is a proportionate means of achieving a legitimate aim. So it's the same question as in relation to indirect discrimination. And then finally, and perhaps most significantly, we have the duty to make reasonable adjustments. And the reason I say that that's perhaps most significant is because it's the positive duty under the Equality Act to make the world a more accessible place for disabled children. And I'll give some examples in a moment of how that works and the way in which you can use the reasonable adjustments duty when we come to look at the duty on schools. There's also a human right not to be discriminated against. And that human right is found in Article 14 of the European Convention on Human Rights, the ECHR. And that's what we all enjoy those rights as a result of the Human Rights Act. And very importantly, for the first and last time today, I'm going to say the word Brexit, and I'm going to say it in order to say that Brexit doesn't change this, because the European Convention on Human Rights is an instrument of the Council of Europe, which we're not at the moment threatening to be. And it is part of English law because of the Human Rights Act, which at the moment, no one's saying they're going to repeal. So unless and until the Human Rights Act is repealed and we leave the Council of Europe, we will still be able to enforce our rights under the European Convention on Human Rights, either in domestic courts at the moment, or if we went back to the old system, we'd have to go off to Strasbourg, the European Court of Human Rights. So Article 14 is the human right not to be discriminated against. And it relates to the enjoyment of our other human rights. And the one that's most usually in play will be our rights under Article 8, which is the right to respect for family and private life. And your private life includes your physical and psychological integrity, your well-being, and your ability to function socially. So it's often engaged by decisions that affect disabled children. And when you're arguing issues around the European Convention rights, you can also bring in other international law principles from the UN Convention on the Rights of the Child or the UN Disability Convention. And most frequently, the one that's brought in is the principle of children's best interests being a primary consideration in all decisions that affect them. We'll look at that again in a moment. But just to give an example to try and make some of this a bit more concrete and real, there was a case brought that I was involved in a few years ago now by the family of a boy called Cameron Matheson. And Cameron was an amazing young man who was very sick and had to spend a lot of time in Alderhay Hospital. And once he had been in hospital for 84 days, his family no longer were paid disability living allowance because it was said that they were getting Cameron maintained free of charge in the hospital, which was nonsense because they were actually incurring more costs as a result of having to travel to visit him and they were less able to work. So it was a complete farce. We challenged that rule, the 84-day rule, on the basis that it discriminated against sick disabled children in hospital compared with those disabled children who were well enough to be cared for at home. And we lost that appeal in the tribunal system, we lost it in the Court of Appeal, but then we won unanimously in the Supreme Court, and the Supreme Court held unanimously that that rule just couldn't be justified. And as a result of that unjustified discrimination, the government and the finding of the Supreme Court, the government changed the rules, and now all disabled children keep their DLA in payment as long as they're in, no matter how long they're in hospital for. So that's a very practical example of human rights law making a real difference to disabled children and their families. I think about 500 families a year benefit from that change in the law. So that's just a little case study. I think there was a question on the chat. I'll just see if that's relevant to what I just said here. So really good question. Thank you, Geraldine. Is do you think it's difficult for a parent to challenge a school using the Disability Discrimination Tribunal? I think there are difficulties, and I would say there are probably two key difficulties. The first difficulty is that disability discrimination law is quite technical, particularly under the Equality Act. And it's not at all straightforward, I'd suggest, to bring a discrimination claim under the Equality Act without getting some pretty good advice, because you have to go through the relevant steps and the relevant stages. So, for example, if you want to claim indirect discrimination, you have to go through the 4 stages that are set out in Section 19 of the Equality Act. And if you don't manage to show that one of those stages is met, then you haven't got a claim. And it's not really fair, I think, for parents to be expected to do that without advice. You can, of course, get advice from IPSI or SOS-SEN, from the Independent Advice and Support Service, the IASS, or from a solicitor, because disability discrimination claims are in scope for legal aid. But that itself may not be straightforward. So there's an issue about the technicality of the law in terms of disability discrimination. The second issue is more of a practical one. It may not be particularly good for parent-school relationships to claim disability discrimination in the tribunal. And it does tend to be, in my experience, that those claims are often brought once a child is leaving or has left the school. It's quite difficult, I think, frequently for parents to bring a claim of discrimination against the current school and then expect that there'll be an ongoing positive relationship. I mean, there should be. And of course, if there isn't, and there's any harassment or victimization, that itself breaches the Equality Act. But just as a matter of common sense, you'd understand that making things as formal as that and claiming disability discrimination could have an adverse effect on positive relations with the school. So I'd suggest that's probably why there are quite low numbers of discrimination claims brought, certainly far fewer discrimination claims brought than appeals to the tribunal in relation to EHC plans. The third problem actually is what you can get from a discrimination claim in the tribunal, because unlike in the county court, the tribunal can't award damages. It can award all sorts of other things. It can order training, it can order changes to policies, it can order an apology, but it can't award damages. And so understandably, people might think, well, what's the point? And there is an issue, I'd suggest, about whether that itself is discriminatory. If anyone ever wants to think about challenging that, do please get in touch. But the parents who bring disability discrimination claims in the tribunal are often doing it because they want a sense of vindication. They want their child to know that they fought for them and that they've challenged what they think are discriminatory practices. And that's completely understandable, but not everyone is going to be in a position to do that. The next question that's come in is about blanket policies around short breaks and thresholds for short breaks. I'll deal with that in more detail when we get to short breaks, but I'm certainly not going to say whether what Trafford are doing is unlawful or not, because that would be completely inappropriate. But what I can say is that those kinds of blanket policies and you can't have unless you have a particular level of disability, for example, may well result in indirect discrimination, because they will disproportionately impact on particular groups of disabled children. And that would have to be justified. And I suppose one justification might be, well, other groups can get services in a different way. But if there isn't an equivalent service in a different way, then there may well be a difficulty in providing the necessary justification. So yes, exactly. If there's a threshold or a criteria that is hard for certain children and young people to meet, then that's exactly the kind of thing you should get advice on. And it may also just straightforwardly be irrational to exclude. For example, I've seen local authorities that continue to use IQ as a cutoff for various services. And as far as I'm aware, there's no rational basis for doing that at all. So in those situations, absolutely advice will be needed from a specialist solicitor, or potentially directly from a barrister, as has happened very effectively with forums in the past. I can be instructed directly without a solicitor, but I can't obtain legal aid. So for individuals who want legal aid, you'll always need to go to a solicitor. Let me just move on to talk about some of the key international law principles. And I'll come back to for any further questions in a moment. So the European Convention on Human Rights I've already mentioned, and the ECHR, which was the founding human rights document after the Second World War in Europe, of course, has been incorporated into English law through the Human Rights Act. That's what the Human Rights Act does. And Section 6 of the Human Rights Act says that it's unlawful for public authorities to act in a way that contradicts the ECHR rights that are set out in Schedule 1 to the Act. Now, the UN Convention on the Rights of the Child and the Disability Convention, the CRPD, they haven't been incorporated into English law, but they're increasingly recognised to be relevant in three ways. First of all, they can inform the development of the common law. Secondly, they can help the court understand how ambiguous legislation should be interpreted. And thirdly, they inform the way in which the European Convention rights are applied in particular. So that's all quite technical. I'd suggest the short point is look at the conventions, look at what the Children's Convention and the Disability Convention say. If you find things in there that are helpful to your situation or group situation in your area, use them, flag them up, rely on them. And if someone says, oh, this isn't law, we don't have to follow it, at that point, you're going to need to get legal advice, because the answer may well be much more complex than that and much more helpful than that from our point of view. What do the instruments say? What's their most relevant sections for us? Well, first of all, Article 23 of the Children's Convention talks about disabled children having a right to full and decent life in conditions which ensure dignity, promote self-reliance, and facilitate the child's active participation in the community. And I'd really like to see people using this more, quoting those words more, because I think that's a pretty good manifesto for the rights of disabled children. And it was written in 1989, so it's not like it's only just been come up with. And it's been adopted by every single country in the world except the United States. So it's as close to a universal declaration of children's rights as we're ever going to get. And within Article 23, there's also a right to special care, subject to available resources. So there is a resource qualification, of course, covering a wide range of different areas, and with the objective of the fullest possible social integration and development for the child. So then moving on to look at one of the key rights of the Disability Convention. This is Article 19 of the CRPD, the Disability Convention of the UN, which is often described as the right to independent living, but it's actually headed the right to independent living and community inclusion, which I think is really important, and it applies to children as much as adults. So it talks about the equal right of all disabled people, persons with disabilities in the UN's language, to live in the community with choices equal to others. And then a specific point that disabled people have the opportunity to choose their place of residence and where and with whom they live on an equal basis with others, and are not obliged to live in a particular living arrangement. Now that's, I think, really powerful, and it certainly is arguably contradicted by the Mental Health Act and the Mental Capacity Act in certain ways. But if you're in a situation where you're not, as a disabled young person, obliged to live somewhere because you've been sectioned under the Mental Health Act, or there's a deprivation of liberty order from the Court of Protection, then you should have the same rights as everyone else, as all your non-disabled peers, to live in your community with choices equal to others. And that, if that isn't happening, then there's a breach of Article 19. The right to participate is hugely important in the UN Convention and in the European Convention itself. Article 8 creates a right to be heard on decisions that impact on people's private life and family life. And that's why I think that local authority panels as a decision-making process which pushes off cases to a panel of potentially unnamed and potentially unaccountable people where families' voices aren't heard are very problematic and potentially breach Article 8 because they infringe this right to be heard on decisions that impact on your private and family life. And then there's specific participation requirements in the Children's Convention and the Disability Convention. In particular, Article 12 of the Children's Convention talks about children's rights to participate in decisions, with their views being given due weight in accordance with their age and maturity. So respect for the evolving capacities of children. And one of the reasons why I get very cross if local authorities ever consult with parents and fail to speak to children and young people themselves is that Article 12 requires the child's own views to be taken into account. The principle from the international conventions that's had the most attention in the case law so far, by a long way, I'd suggest, is the best interest principle in Article 3 of the Children's Convention and Article 7 of the Disability Convention. That was the relevant international law principle in Cameron Matheson's case. And what the conventions say is that in all actions concerning children, the best interests of the child shall be a primary consideration. And that means, the Supreme Court's told us, that they should be considered first. The interests of children should be considered first, but they can be outweighed by other factors. For example, cost being one of them. So it's not a trump card necessarily, the best interest of the child, but it does mean that local authorities and health bodies must always start from the position of what's in the best interest of children. And if they can't deliver on that, it must be because of countervailing factors of considerable force, as Lord Kerr said in one case. So I think that's really powerful, and it means that disabled children generally, and disabled children in particular, should be at the forefront of decision makers' minds when, for example, budgets are being set locally, because the best interests of children must always be a primary consideration. And then we see that that particularly is reflected in domestic law in Section 11 of the Children Act 2004, Section 175 of the Education Act 2002, which both call for regard to the need to safeguard and promote the welfare of children. So similar language to Article 3 of the Children's Convention. Not quite the same, but similar. Lady Hales said that these reflect the spirit, if not the letter, of Article 3. And Lady Hales also told us, the former president of the Supreme Court, that having regard to the need to safeguard and promote the welfare of children means thinking about two different things. Safeguarding is one thing, keeping children safe, but promoting children's welfare goes beyond that, and local authorities must always have that in mind as well. And then disabled children will have the benefit of Section 149 of the Equality Act 2010, the public sector equality duty, in relation to their protected characteristic of disability. And that requires public bodies to have due regard to a series of specified needs when they're doing anything, when they're carrying out their functions. And that includes the need to eliminate discrimination, but also the need to advance equality of opportunity for disabled children vis-a-vis their non-disabled peers. And so when you put these two together, we can see that Parliament has said to public bodies, consider the need to safeguard and promote the welfare of children, have due regard to the need to advance equality of opportunity for disabled people. And so for disabled children, I would suggest again that there's got to be a degree of priority given to their interests as a result of Section 11 and Section 149. And there's a couple of questions in on the chat, which I'll just check in on. Is there a cut-off for local authorities to consult children? Absolutely not. So the duties in the Children's Convention, the UN Convention on the Rights of the Child, apply from 0 to 18. Why don't I just show you briefly what Article 12 says? It's always quite useful to look at the actual source material sometimes. Hopefully you can all still see my screen. I'm literally just going to look up on a popular search engine, UN Convention on the Rights of the Child. There it is. Yeah, I've been to this one before, unsurprisingly. And the UNICEF website is great, but then you've got to find full CRC. There we go. And this is it in all its glory. And I will just go straight for the purposes to Article 12, where it says, state parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. So that means that in order for there to be a benefit under Article 12, the child has to be capable of forming his or her own views. I know lots of very small children that are perfectly capable of forming their own views about things. That doesn't mean they have to be able to express those views orally or in writing. It just means they have to have an opinion about things. And only cast your mind back to many toddlers you'll have known are perfectly capable of having a view and forming an opinion about things. And the respect that we give to those views, the due weight, is informed by the age and maturity of the child. So every child has the right to express their views freely in all matters affecting them. but the weight that's given to the views depends on their age and maturity, which will take into account issues around their disabilities and impairments as well. So every child may express, but some children's views can be given little, if any, weight. The older the child, the more mature, the greater the weight that should be given to their views. And some children will be Gillick competent, of course, which is a principle from the old case of Gillick in the House of Lords around access to contraception. Children who have sufficient maturity and understanding can make decisions for themselves. And we cover that very difficult issue of decision-making and children's competence, as it's called, in Disabled Children, a Legal Handbook, in the decision-making chapter, if anyone has particular concerns about that. Go back to the slides. So that's all, I hope, been some useful background. And what I've been trying to set up, as you probably noticed in that part of the talk, is this idea that disabled children should be a local priority and that the needs of disabled children shouldn't come last. They should come first in allocation of resources, for example, and other key local decisions. I'll move on now to the Children and Families Act. And I think that before I go into the slides, I'll just show you where it is and where you find it, and you'll be unsurprised to know what I'm about to do. I'm about to use a popular search engine to search Children and Families Act 2014. And you're looking for the legislation.gov.uk website as the official source. And hopefully you'll find that it's up to date. Now, this is the original version. I'm not sure there have been any amendments to the primary legislation, but you have to be a bit careful because sometimes legislation.gov.uk doesn't capture all the recent amendments. We know that Part 3 of the Children and Families Act is our part, children and young people in England with special educational needs or disabilities. And people who've never looked at the law before will now know that it comes in sections. Section 19 is the first section in Part 3. And I'll now go back to the slides because it's slightly easier to see the text there. Section 19 says that in exercising a function under this part, in the case of a child or young person, a local authority must have regard to. So it's another one of these think about duties. They must consider certain things. And what they have to consider is the need to support the child and his or her parent or the young person, etc., in order to help them achieve the best possible educational and other outcomes. So that's the goal, that's the objective under the Children and Families Act. It's not something that they have to achieve. It's a target for them to achieve. So what we shouldn't see is local authorities saying, we are only aiming for an adequate service. We're only aiming for what's achievable in the limited resources we have available. The target must be the best possible educational and other outcomes for children and young people. We then get some key definitions in section 21 of the Act. First of all, special educational needs, a learning difficulty or disability that calls for special educational provision. So it can be either a learning difficulty or a disability that leads to a need for special educational provision, SEP. And what is SEP? It's educational or training provision that's additional to or different from that made generally for others of the same age in mainstream schools in England. And importantly in that sentence, it's the last two words, because the comparator that you're looking at is what's there generally across the country, not what is there in the particular local authority. And then we get a very important definition point in section 21, subsection 5. Healthcare provision, so things that the NHS provides, or social care provision provided by local authorities under their social care duty, which educates or trains a child or young person, becomes special educational provision instead of health or social care. So it transmogrifies, it changes its shape, and it becomes educational provision for the purposes of the Children and Families Act, so in particular in relation to EHC plans. And that's set out in section 21, subsection 5. And it means that in almost all cases, therapy provision, for example, should be in section F of the child or young person's EHC plan, because it will be educating or training the child or young person. Even if the workers who provide that therapy are employed by the CCG or by another health body, it doesn't really matter who funds it generally, because the responsibility to secure that provision will then fall on the local authority, because it is educating or training the child or young person. And what this really goes to is the fact that the Children and Families Act is essentially an education act with health and social care bolted on. And the focus is always on education, as we're going to see throughout. But before we get there, I must also stress there's a divide between health and social care for children as well. So TD and B and Haringey is the key case on that, concerning a 3-year-old child who had a tracheostomy and needed significant levels of nursing care. And the court in the Haringey case said that the child's health needs were so intense that it was unlawful for the local authority to provide care to her. Local authorities were not allowed to act as a substitute NHS for children. And so there are some services that can only be provided, some needs that can only be met by the NHS. And that's why we have this national framework for children and young people's care, which I'll come back to. Before we get there though, must emphasise that for most disabled children, the support they're going to get and need is from school. The vast majority of children, that will be their main or only source of services. And there remains a presumption in favour of maintained and mainstream schooling in the Act. And in mainstream schools, the expectation is that needs will be met generally at the SEN support level, which is a non-statutory process. It's from the Code of Practice, it's not in the legislation. And the Code of Practice describes this 4-part cycle of assessment, planning, delivery, and review, all funded through the school's notional SEN budget with any top-up funding from the local authority. And it's really important to keep in mind that school governors and academy proprietors have this best endeavours duty in section 66 of the Children and Families Act, and that still applies and hasn't been eased or moderated in any way. So the schools must use their best endeavours to secure the special educational provision that all pupils need, not just those with EHC plans, but also including those with EHC plans. And so that's obviously a very relevant duty to be referencing at the moment if children and young people are on school roll but out of school because of the pandemic. The school must still use their best endeavours to provide the provision that they require. And schools have duties to meet children and young people's medical needs as well, being those health needs that might impact on their ability to be at school safely, but which don't result themselves directly in educational needs. And there's some very good statutory guidance on that duty, emphasising the role of the clinical commissioning group to come in and top up where there are particularly extensive medical needs, but that schools generally are supposed to meet those needs in the main run of cases. I said I'd come back to the reasonable adjustments duty on schools, and I will do that now. And the duty to make reasonable adjustments on schools applies firstly to their policies, so their provisions, criteria or practices, and then secondly to the auxiliary aids and services they might need to supply. And that can include people, so a teaching assistant to go on a class trip with a school to help a disabled child so that their parent doesn't have to go or the child isn't excluded from that trip would be an auxiliary aid or service under the Equality Act, under the Reasonable Adjustments Duty, Section 2021. So when do schools have to make reasonable adjustments? Well, the key point is there's no fixed definition, and they must make any adjustments that will be reasonable for them to make to avoid the disadvantage that disabled children are facing. And so that means considering all the circumstances, not just the benefit for the child, although that's obviously an important starting point, but also what would the cost be, would there be detriment for any other children, and so on. And the duty is anticipatory, which means that schools have to think about what reasonable adjustments they can make, not just for their current pupils, but for potential future pupils as well. And an observation that's come in, a helpful one from Simon, preempting what I'm about to say, correctly highlighting that schools still have the best endeavours duty to try to meet needs, but the local authority has the reasonable endeavours duty currently to make provision in Section F of the plan. Now, Simon, you've rightly flagged that up, but you're getting ahead of me because I haven't yet introduced people to the main duty to secure provision in plans. I will come to that, I promise. But you're absolutely right to highlight that where a child has an EHC plan, the primary duty to secure provision in Section F is on the local authority, and that the duty to arrange the health provision is on the CCG. Schools still have the underlying best endeavour duty, but for children with plans, the starting point would always be for any good solicitor to go to the local authority and say, you're not making things happen in accordance with the plan. That duty has been eased into a reasonable endeavours duty, and for at least for this month, and I'll explain that a little more when we get to that point. So school reasonable adjustments duty, describing their anticipatory nature of the duty. And it's worth bearing in mind that you might get an auxiliary aid and service either from the school under the reasonable adjustments route or from the local authority by getting it written into section F of an EHC plan. It's deliberately an overlapping framework in order to give children and young people the greatest possible entitlements. Of course, if you're getting it from the local authority under section F, it wouldn't be reasonable for the local authority, for the school, sorry, to do it again. Importantly, schools can't charge for reasonable adjustments. They have to be made free of charge, but the cost of making the adjustment is relevant to whether it would be reasonable to do it, as is the resources available to the school. So what it would be reasonable for a large academy chain operating a big secondary academy to do may well be very different to what it would be reasonable to expect a small village primary or infant school to do. Schools have to prepare accessibility plans in relation to their physical features, because physical features of schools are not covered by reasonable adjustments duty, whereas physical features of other bodies, service providers, for example, are. And the remedy, as with all school disability discrimination issues, is this appeal to the tribunal to SENDIST, the DIS part of SENDIST. And in any appeal like that, you'd be thinking about discrimination arising from disability and or indirect discrimination as well. It would be quite unusual for the claim to only be, but there's a failure to make reasonable adjustments. Now, questions come in about the Autism Act, and hopefully it will still include children. Well, soon, include children. Well, yes, it is to be hoped it may be amended, the Autism Act, to include children. But I have my doubts that will happen anytime soon, given the current public health crisis. And also, what will matter is what does it extend the scope to cover? Because at the moment, the Autism Act is much more of an act around diagnosis, frankly, and post-diagnosis interventions, than it is an act about giving anyone an entitlement to services and support. And it essentially just tracks the CARE Act in terms of support for adults with autism. So it's not just a question of extending the Autism Act to children. It will also matter very much what precisely it says. So we'll have to watch the space for that. School exclusions, sadly, a very important theme. We know that heads have the power to exclude from pretty much any school or college, but that exclusion must be for disciplinary reasons, and it must be either a permanent exclusion or a specified fixed term exclusion. What's unlawful is schools encouraging children to stay away at lunchtime perhaps, or not coming in on a Tuesday afternoon, or whatever it might be. Those informal exclusions are all unlawful. We know that children with SEND are much more likely to be excluded from school than their peers, including children with EHC plans, even though the guidance essentially says don't exclude children with EHC plans. And what's very upsetting and concerning is when you see exclusion being misused as a way to manage out children from schools that they're attending that just aren't suitable for them. Because in that situation, what should happen is that there should be an emergency review of the EHC plan, or if there isn't an EHC plan, there would have to be a very expedited assessment. And a new school should be named in section I, and the child should move if everyone agrees. And of course, otherwise there's a right of appeal to the tribunal for the parents. But we shouldn't see children being excluded just to get the local authority's attention and to get some support, because that exclusion stays on their record and may impact on their life chances. So, as well as just being completely inappropriate if it's not being used for disciplinary reasons. Permanent exclusions can be appealed to the independent review panel, which can recommend reinstatement but can't order it anymore. And you can also bring, of course, a disability discrimination claim. And if you do bring a claim like that, thanks to Mr. and Mrs. C, who instructed me to appeal to the upper tribunal in their case, we've managed to establish that the old rule that knocked out children who had what's described as a tendency to physical abuse shouldn't apply in these cases. And all children with autism or other conditions who may behave in a challenging way can still claim that they're disabled, they are still disabled, and they have the protection under the Equality Act. And what will matter is whether or not what's been done is proportionate, if, for example, a discrimination arising from disability claim is met. So thanks to Mr. and Mrs. C, the full protection of the Equality Act still applies in this area. I'm asked about, do I have any data on the IRP? As the viewers, they seem to back up the school governor body decision. I don't have any access to any data about that. I do have concerns about the effectiveness of the IRP as a remedy. If I was in a position where I wanted a child to go back to school, I would seriously think about whether judicial review was the right remedy, because the IRP lacks the power to force the child to go back to school. And so it's important to get advice, I'd suggest, in the particular case at the particular time as to whether going to the IRP is the right thing to do. And you may decide instead to go to the tribunal. I think you have to choose which of those you want to progress first, and there are implications for timescales and so on. So it's important to get advice on those situations. And what about children who are out of education? Well, this is going to be very important at the moment, of course. Section 19 of the Education Act 1996. And interestingly, the Coronavirus Act gave the Secretary of State the power to modify Section 19, but he hasn't done so yet. The only modification that's been made is to the duty to secure provision in the HC plans, which you'll see in a moment. Section 19 remains fully in force, and it says that local authorities have to make arrangements for the provision of suitable education at school or otherwise, so it's often referred to as education otherwise, for children of compulsory school age, so we're talking up to GCSEs, who may not for any period receive suitable education, essentially for any reason, unless such arrangements are made for them. And that education should be full-time unless the child needs less. There was a very important case, an old case called Ex parte Tandi, which said local authorities can't use their resources as a reason for limiting provision under Section 19. And so if children are out of school at the moment for coronavirus-related reasons, they should still be getting provision under Section 19 otherwise than at school, unless it's not appropriate in their particular situation. And as I say, the Secretary of State must have deliberately decided that at the moment, it's not necessary or appropriate to ease Section 19 because he hasn't exercised his power to do so. And by having Section 19 in place and by ensuring it's complied with, as a society, we ensure compliance with the human right to education in Article 2 of the first protocol of the European Convention, which is quite a weak right because it's not a right to any particular type or kind of education, but it is a right not to be excluded from the education system. And that's why it's important that Section 19 is given full effect so that children are not just left languishing without education in a way that would breach their human rights. So that's essentially what I was going to say about schools before we get to EHC plans. We'll move on briefly to look at social care. At the moment, I'm just seeing one more question that's come in. Can parents say they don't want school support during COVID? Can you say you don't want school support? I think that's slightly more difficult. Can you say you don't want the child to attend school? Yes. And I'll show you why the answer to that is so obvious. Because of this guidance, people may well be familiar with. Supporting vulnerable children and young people during the coronavirus outbreak. And although there's an encouragement for vulnerable children and young people to attend educational settings, unless they've got underlying health conditions, there's no requirement to do so. And being a vulnerable child has now been amended to include those who have an education, health and care plan, whose needs cannot be met safely in the home environment. So at the moment, it's expected that only those children and young people with EHC plans who are not safe at home for whatever reason, needs can't be met safely at home, will be vulnerable and therefore be expected and encouraged to attend school. So you can, as it says here, choose, and it's a choice for parents as to whether or not to attend. And it says very clearly, when a risk assessment determines that a child or young person with an EHC plan will be safer at home, our recommendation is that they stay at home. Where they'll be as safe or safer in an education setting, the recommendation is that they attend. But I'm pretty sure somewhere it says that the person who gets to decide this is ultimately the parent. So there shouldn't be any requirement to attend. But there is a requirement to ensure that children are educated. And so if the school are offering to send work home and support people to provide education at home, the expectation is that will be done and that people will work together to make that happen. But there does have to be a recognition, I suggest, of the reality of the situation for children and families. And if families are under a lot of pressure, there certainly shouldn't be generous obligations being put on them in terms of work. It should very much be a partnership approach. So in terms of social care, a message that I think this forum will probably be well aware of, but I'm going to reiterate, is that all disabled children are children in need under Section 17 of the Children Act 1989. And that is a fundamental point that's often lost sight of. You don't need to be anything else, you just need to be a disabled child in order to qualify as a child in need. And all children in need are entitled to some form of assessment in accordance with the Working Together to Safeguard Children statutory guidance. They aren't necessarily entitled to a social worker-led assessment. We know that from the Warwickshire case that I was involved in. But someone appropriate, someone who reasonably competent to assess, must carry out that assessment. And it must be done within a maximum of 45 working days with an immediate response in urgent cases. And where services are going to be provided, they have to be set out in the child in need plan. And that needs to say who's going to do what, where, when, and how to help the child. Now, the problem with Section 17 of the Children Act is that although there's a duty to assess every child who is or may be a child in need, there isn't a duty to provide services to individual children in need. There's a general duty to have services for children in need generally, not one that's owed to any individual child. And so that's why the Section 2 duty in the Chronically Sick and Disabled Persons Act is so important. How does the CSDPA work? Well, it's a duty to provide an extensive list of different services where that's necessary to meet the person's needs. And those services include practical assistance in the home, so domiciliary care. They include community-based short breaks, support with adaptations to the home, holidays for the family together, and so on. Now, the local authority is allowed to take account of its resources when it's deciding the question of whether it's necessary to meet the child's needs to provide the service. So they can have, in principle, eligibility criteria to say some children with needs will not have their needs met because they're not intense enough, they don't meet our criteria. But once the need does meet the eligibility criteria and it is accepted that it's necessary to meet the child's needs to provide the service, then a sufficient level of service must be provided, or in modern times, a sufficient amount of money in the form of a direct payment to buy sufficient services to meet them. So the cost of the value of the direct payment has to be referable to the services that are actually going to meet the child's needs, not to any fixed amount of money the local authority may set as a direct payment rate, for example. So the Section 2 duty is absolutely fundamental. It is rather surprising, I suggest, that we're still here 50 years on talking about the Chronically Sick and Disabled Persons Act from 1970. It's even older than me. And it has been amended, of course, very significantly, but it is still a rather out-of-date approach. And it's very different, as we'll see when I get to it briefly and when I spend much more time on it on Monday, to the Care Act, which is an act that is much more focused on meeting needs than it is about any particular kind of service being provided. There are also some key duties that were put in place in relation to short breaks for disabled children and young people. Through the Aiming High for Disabled Children programme, at the same time as investing lots of money in short breaks, there was this amendment to the law through the Breaks for Carers of Disabled Children regulations. Just three quick regulations to go through on this, and then I'll have another look at the questions. First of all, Regulation 3 says that local authorities must have regard to the needs of carers who'd be able to provide care for their disabled child more effectively, interesting language, if breaks were given to them to allow them to do any of the three ordinary life activity areas that are set out on the slide. What isn't on the slide here is work. And that's because the service that supports work is childcare under the Childcare Act 2006, which is legally a distinct thing from a short break. So the purpose of a short break is to allow families to lead ordinary lives where the child goes away from the parents for a while and has their own experiences, and the parents and perhaps siblings do other things either together or separately in accordance with these bullet points here. So that's what local authorities have to think about, to have regard to. They've also have a duty to provide, so far as reasonably practicable, a range of services that's sufficient in their area to assist carers to continue to provide care or do some work. And that has to include the full range of daytime, overnight care, leisure activities, holiday care, and so on. Regulation 5 says that they must set all this out in a short break services statement, which must give the range of services, any eligibility criteria for those services, and how the range of services is designed to meet the needs of carers in the area. Questions, please. So I'm asked what's the best way to challenge the lack of services provided by the local authority in social care, which is obviously a very important question. The starting point should always be to raise the issue with an appropriate person within the local authority in terms of relevant social care officers, social worker, manager, whoever it might be. Normally you'd say that one of the ways to deal with this would be by a complaint, and local authorities are still generally operating their own complaints process. But the local government ombudsman, which is the independent stage at the end of the complaints process, has shut up shop for the duration of the pandemic. And so the complaints process isn't likely to be very effective for, certainly if you need to go outside of the local authority to the Ombudsman at the moment. And so the best way to challenge urgent and serious issues in relation to lack of social care will be through judicial review. And that's what I will spend quite a lot of my time advising on and acting in, is cases where there's policies or practices that mean that disabled children are not getting social care that they arguably need. So that's exactly the kind of scenario where you will need to get specialist legal advice. Residential short breaks are a problematic legal area because they're the only important social care service that you can't get under the 1970 Act. In JL and Islington, the High Court said that accommodation can't be provided under the 1970 Act. It's not something you can read into the list of services. So how are you going to get this overnight accommodation? Well, if your family is at crisis point, then there would be a duty under Section 20 of the Children Act 1989 to provide that accommodation. And children who are accommodated under Section 20, and that can also include children who go away from home for significant periods of time or to more than one short break setting, they become looked after children, which is the same status as children who are in local authority care. But critically importantly, they are not in local authority care. The parents still have full parental responsibility, and that accommodation can be terminated at any time. It's voluntary accommodation. But there's a real confusion about this. And because it's the same legal status, parents often feel there's going to be real stigma associated with their child being looked after. The problem is that if children go away from home and they're not looked after, they don't get the same package of safeguards and support. They don't get the same rights to independent reviewing officers, to visits, to more detailed care planning, and so on. So generally, I would say that where disabled children are going away from home for significant periods of time, it's appropriate and necessary for them to be looked after children for that period. That doesn't mean there's anything wrong with their parents parenting. It means that they are being looked after while they're away from home, and they have those additional safeguards. But I do understand that in some areas that there's a real confusion about this, and it may be necessary to take specific legal advice. If it's not a Section 20 placement, then it will be under Section 17 of the Children Act 1989. Which has a general duty, as I've said, to provide services, and that can include accommodation, but it's very hard to demonstrate that there's a right to services under Section 17. The decision not to provide services would effectively have to be irrational. There was a very recent case involving the London Borough of Bexley for a family that had no recourse to public funds, where the local authority were refusing to provide enough funding for the adult sibling of a child, saying that he wasn't eligible, he didn't qualify. And the court said that was wrong, and that he could get support under the Children Act, but that there was nothing irrational about their decision not to provide support to him. And that's why, well, a really good example, I think, of how difficult it is to get services under Section 17 unless the local authority wants to provide those services, because it is only a general duty to provide. Follow-up question, are judicial reviews still taking place at present? Answer, yes, absolutely. The Administrative Court is sitting remotely, as is the SENDIST. And so I'm regularly involved in cases that may well end up in front of a judge on a screen rather like this one, perhaps using Zoom, although the courts have their own platform. So it's a rather odd experience, but absolutely it's a viable mechanism still. And there's a duty judge available every single day in the Administrative Court if things are really urgent, that you can get immediate orders, for example, to accommodate a homeless child. How about parent carers of disabled children? So there's a right under Section 97 of the Children and Families Act for parent carers to have their own needs assessed through a PCNA, a parent carer's needs assessment. And that should be done alongside the assessment of a disabled child and of any siblings who may also be young carers or maybe children in need in their own right. And thankfully, there's a power, as you see in Section 17 ZE3, to combine all these assessments. So what we should be looking for is a holistic and a joined up approach where assessments are done of all the family members at the same time in a joined up way to avoid people having to say the same things over and over again. But at the same time, parent carers are entitled to be assessed separately if that's what they want, to talk about their own needs away from the child's context. There isn't, though, a new duty to provide services to parent carers of disabled children, compare with the duty to provide services to carers of disabled adults over 18 or over under the Care Act. What's required under Section 17 ZF is consideration of the PCA, parent carers needs assessment, answer these questions that are on the slide, the local authority must do, but then in particular decide whether or not to provide services in relation to the parent carer or the disabled child. So there's a duty to make a decision, but not a duty to actually provide services. And so what the point of a parent carer's needs assessment is, in my view, is to make sure that the decision about the package of care for the disabled child and the family is properly informed and properly joined up, so that there's a rational and well-informed basis for the decision about the level of care. That's what it's supposed to be. And just to finish up before we have our break, because it's the last slide before we get to the EHC process, to mention the National Framework for Children and Young People's Continuing Care, which is, as it says, designed for complex cases, who are children with complex needs, but those complexities could be around behavioural needs and or communication needs. So it's not just about children who have issues around skin integrity or breathing, for example. It can be issues around behavioural communication, which means that some children with autism should come into the scope of eligibility for children's continuing care. There's a pre-assessment checklist that you can use to see if your child might be eligible. And then the key document is the decision support tool across these 10 domains of need, where we look at how intense the needs are. And although that tool is not supposed to determine the outcome, in my experience, it often seems to in practice through the decision support tool. And then the whole process is supposed to be very quick. Within 6 to 8 weeks, there should be a decision about eligibility for continuing care. And it seems to be that the expectation is that the package of care would then be led by the clinical commissioning group, although there isn't in the guidance as clear an either or split for children's continuing care as we see in the adult framework. Right, any final questions for now about any things I've just said? Because otherwise we'll have our own short break, and we'll come back at 2:30 when I'll get into the detail of the EHC process, and then we can look at the easements, the changes to the law that have come about in the last few weeks in relation to coronavirus. Okay, I'm not seeing any other burning questions on the chat. I'll come out of the slides. I'll stop sharing my screen for now. Thanks very much, everyone, for sticking with me so far. I'm hoping you're all still there and that you're all still awake. And we'll have a break and come back at 2:30, if that's okay.
Yeah, that's great. So if everyone just gets back for 2:30 for the second part. Thanks, Steve.
Lovely. See you all in 10, 12 minutes or so.
Brilliant.
Cheers.
Thank you.
still on video. Hope you're all sufficiently refreshed. Managed to get some more caffeine or whatever it is that keeps you going. I'm going to start sharing my screen again, and we're on until 3:30, with me focusing now pretty much on the EHC plans and what's happening with them for most of the rest of the time. Although I'm very much welcome any questions people have thought up over the break as well about any of the issues I've spoken about already. So EHC plans then. I'm going to suggest at the beginning of this part of the talk that EHC plans are essentially statements of SEN+. They are education-focused documents with health and social care bolted on. And in fact, that's made crystal clear, I'd suggest, from the very outset in terms of the duty to carry out the EHC needs assessment in section 36. All the section references here, of course, are to the Children and Families Act. So the duty to carry out an EHC needs assessment arises where the child or young person has or may have SEN, low threshold, and it may be necessary for special educational provision to be made in accordance with the plan. So you could have a child with the most complex health or social care needs, and they won't get an EHC plan because they don't have a significant level of special educational needs. So it's very much an education-focused scheme. And at this stage, the local authority only has to be satisfied that it may be necessary for there to be a plan. Now that could be because it may be possible that the child is going to go to a special school, or it could be because it may be necessary to make provision that's beyond that can reasonably be expected to be provided by mainstream schools from their own budget, or it could be for other reasons. There's no fixed definition of what might make it necessary to carry out an assessment. And we know that the threshold is low, and the vast majority, over 90% of appeals against refusals to assess by local authorities are upheld by the tribunal. So it's very important that parents do challenge a decision not to assess, because the bar is not designed to be set very high at that point at all. If an assessment is done, either because it's been agreed or because it's been ordered by the tribunal, then in every case, the local authority must get the advice and information that's required by Regulation 6 of the same regulation. So let me just show you that. Am I sharing my screen? No, I'm not sharing my screen. I'm sorry. Try it again. Hopefully I am now. Sorry you didn't see those slides. I'll just go back and show you the two slides. So I've talked to, first of all, this slide that talks about section 36 and the test, and then I was on the advice and information requirements in Regulation 6. So if we find that within the SEND regulations, information and advice to be obtained. This is my least favorite bit of drafting. Information and advice to be obtained of EHC needs assessments. So wherever local authority secures an EHC needs assessment for a child or young person, it must seek the following advice and information on the needs, the provision, and the outcomes. And that advice and information has to come from, obviously, the parent or the young person, educational advice and information from the school or setting, medical advice and information from a healthcare professional identified by the CCG, psychological advice and information from an educational psychologist. So an EdPsych must be involved in every case and must provide that, or must be requested to provide that advice and information. Advice and information in relation to social care. Doesn't have to necessarily be from the local authority's own team, but usually would be. A response that says we don't know this child is hardly providing advice and information in relation to needs, provision and outcomes. And my view is that the local authority would in that situation at least have to offer some form of social care assessment in order to gather that information if the family may want social care. But the family can of course say no. Advice and information from anyone else the local authority thinks is appropriate. Advice and information in relation to transition to adulthood for those in or beyond year 9. And importantly, advice and information from any person the child's parent or young person reasonably requests that they get that advice from. And then some specific requirements in terms of those with sensory impairments. So very long list of professionals' advice and other advice that must be obtained in every case. Unless the child or young person, unless the parent or the young person agrees that it's not needed. And my question would be, why would you do that? Because part of the point of having an EHC needs assessment is to get up-to-date advice about needs provision and outcomes. And it's unlikely that any other advice that's been obtained or assessments that have been done will cover those three things. And then the next stage in the process is, are the local authority going to issue the plan? And the test has now become, unsurprisingly under section 37 of the Act, that it is necessary for special education provision to be made in accordance with the plan. And a key question, although not the only question, we've been told by the upper tribunal, is whether the provision that's required by that child or young person could reasonably be provided from the resources normally available to maintain schools. So the cost is a very important factor, but there could be others, again, that the child needs to go to a special school. That's an obvious reason why it would be necessary for them to have an EHC plan. Or I've had a case where it was accepted that the complexity and the intricate nature of the provision meant that it was appropriate for it to all be set out in a plan that gives that legally binding guarantee, at least in normal times. So it's not just a question of cost, although cost is very important. So above this £6,000 figure that schools are supposed to be able to find themselves, it is very likely to result in a plan being issued, and below it may well result in a decision not to issue the plan, which could then be appealed to the tribunal. Timescales. This is where we get our first key easement for today's purposes. The SEN Code of Practice, paragraph 9.4, very helpfully sets out and summarises the timescales that the whole process of needs assessment and plan development, from the point of request the request is made to issuing the plan, must take no more than 20 weeks. Well, that was the case until these regulations were introduced. The amendment regulations in relation to coronavirus that were passed in late April, late before Parliament on the 30th of April, and came into force on the 1st of May, as we can see. And they're quite technical. They go through and they amend 4 different sets of regulations, including the main SEND regulations. And the easiest way to see what they do is actually to look at Regulation 5. And you can see that that introduces a new Regulation 2A into the SEND regulations. And it describes something called, not the latest Jason Bourne thriller, the coronavirus exception. So where the coronavirus exception applies, any requirement in any of the regulations specified below for action to be taken within a specified period of time or by a certain date is to be read instead as a requirement for such action to be taken as soon as reasonably practicable. But the specific timescales have been eased, and instead local authorities have to do things as soon as they reasonably can, where the coronavirus exception applies. And then we're told below what the coronavirus exception is. It's where it's not reasonably practicable for a person to meet a requirement referred to in the regulations for a reason relating to coronavirus. So the key point is that it's an individual case decision. Local authorities cannot have a blanket rule of saying, oh, we've decided we're no longer going to complete EHC needs assessments in the specified time frame. They have to say in a particular individual case, there's a reason which makes it not reasonably practicable for us to do so, and therefore we have to do it as soon as reasonably practicable. And then you'll see that the following regulations, which give a whole range of different specific timeframes for different stages in the process, are eased in this way, including, importantly, and this isn't currently recognised in the guidance, the requirement to comply with orders from the tribunal. The guidance recognises that there's an easing of the requirement to address non-binding recommendations in relation to health and social care, but it doesn't recognise at the moment, and it should do, that actually local authorities only have to comply with tribunal orders now if the coronavirus exception applies, as soon as reasonably practicable. And then just to pick up a point that will be relevant later on, annual reviews, we get in an easing of Regulation 22, which is the duty to amend an EHC plan following a review, with a new subsection put in place, new sub-regulation put in place. The local authority need not comply with the time limit for that stage of the process if it's impracticable to do so because of a reason related to coronavirus. So the general scheme of all of this is to take away the specific timeframes and create a duty for the local authority to do things as soon as reasonably practicable. I'm going to check a question that's come in. So one of the questions is actually on a slightly earlier stage, was about EHC needs assessment. Is there case law along the lines of child just having to show SEN to satisfy the test? No, that can't be right, because the test for an EHC needs assessment is 2-part. So the first part is that they may have SEN, but then the second part is that it may be necessary for them to have an EHC plan in order for the special educational provision to be made. So there definitely has to be a realistic possibility that they'll need an EHC plan. So if the child only needed a very modest amount of additional support that every school would easily be able to provide, then it would be hard to show that it might be necessary for them to have a plan. There'd be no requirement to assess. But it's only at that stage that it may be necessary. It just has to be a realistic possibility, I'd suggest. So that's the easements in terms of the EHC process. So where the code of practice says that there's a 20-week maximum time frame, that now has to be read in accordance with the regulations as saying subject to the coronavirus exception. If it's not reasonably practicable for us to do it in that time, we must do it as soon as reasonably practicable. So how about the EHC plan itself once it's been produced? Now, anyone who's seen an EHC plan will know that it's in certain specified sections, and section A, not on the slide, is the aspiration section written by the family. Sections B, C and D are the education, health and care needs, and it's very important that those set out all of the relevant needs, and the educational needs will be divided across 4 main areas, of course. And then section E is the outcome section, which is very important, particularly for older children and young people, because it will help determine whether or not the plan will continue post compulsory education. I'll talk about that more on Monday. And then section F is the special educational provision, and that must be tracked against section B. So the requirement is that there's provision in place to meet each and every one of the educational needs identified in section B. Bearing in mind this rule that any provision which educates or trains the child or young person is educational provision, and so should go in section F. Section G then is all the additional health provision that isn't educational provision for this purpose, that doesn't educate or train the child or young person. And section H is the social care provision that doesn't educate or train. And that's divided into H1 and H2 because of the Chronically Sick and Disabled Persons Act. There was a recognition of a need to acknowledge that some children will have rights under the CSDPA, and those services go in section H1 and everything else goes in H2. So for a child, you absolutely want the social care provision to be recorded in section H1. But actually, as we'll see in a moment, the Children and Families Act doesn't create any new entitlement to social care support anyway. So really, this is just recording what the child is already entitled to following a Children Act assessment and a decision as to eligibility and entitlement under the CSDPA. Section I of the EHC plan is then the placement that the child's going to attend, and the tribunal has confirmed, the upper tribunal has confirmed that that can be left blank in a case where the child is going to be educated at home or otherwise than in a school or college, because it has to be an institution that's named in section I, and a person's own home can't be an institution. So in those cases where the child's being educated at home through, for example, an ABA program or any other kind of home program, that would result in section I being left blank, and the provision would be specified in section F. Otherwise, if the child's attending a school in the ordinary way, that will go in section I, and there will then be a duty on that school to admit the child or young person under section 43 of the Act. They will have no choice but to admit them if they are named in section I. And section J is then any direct payment that's going to be made. Now, up until now, this hasn't been particularly significant, I'd suggest, because it's been quite difficult to get an SEN direct payment, which was introduced by the Children and Families Act. Because in order to qualify, you would have to show that it wasn't going to cost the local authority anymore to make the provision that way. And that meant, for example, if you wanted a direct payment for speech and language therapy, but there was therapy available from the commissioned service, you wouldn't get a direct payment. They'd offer you the commissioned service instead. But in the current situation, it might be that actually local authorities are willing or can be persuaded to make direct payments more readily, because there isn't the same availability of commissioned services. And so having an SEN direct payment could become rather more useful. What we haven't worked out yet, and I may try and do so, is whether you could use an SEN direct payment to pay family members to provide educational therapy. It is clear that you can use social care and health direct payments to pay family members to provide care if the local authority or the CCG accepts that it's necessary to do so. I've written about this for Special Needs Jungle in a couple of articles, one of which I will bring up now, and I'll put it in the chat. It might hopefully mean that people can click links if they need to. That's oh, sorry, no, I sent that just to one person. I'll send it to everyone now. That's the article that I've just brought up in terms of using indirect payments to pay family members to provide care, but we don't yet have clarity as to whether you can use the indirect payments to pay family members. So I'm going to see if we can get some clarity about that. I'll just pick up a couple of questions while I'm in the chat. An example of a reason a local authority could give for using the impact of coronavirus as a reason not to meet timescales. All the educational psychologists are off sick, for example, so we can't get the advice and information we need in the usual time frame, or all the administration within the local authority are off sick, or people have been redeployed to other frontline coronavirus related tasks. Those kinds of reasons, I think, will be examples of where the local authority are able to say we can't meet the timescale. But they aren't limited deliberately in the way that the regulations are drafted. It could be any reason that's genuinely coronavirus related. Could a local authority create a list of reasonable endeavours? Could this not facilitate blanket policies? Let me come back to that in just a moment, because I haven't yet talked about the section 42. Just been looking at the regulations so far, which, as we've seen very clearly, are about individual children and young people's cases and the timescales for those. So watch this space in terms of SEN direct payments. It could become more significant. Now we're on to the duty to provide. So once you've got your EHC plan, and it sets out in it the provision that needs to be made in terms of the section F and section D of the plan. Section 42 of the Children and Families Act provides that local authorities must secure the special educational provision for the child or young person. And if the plan has healthcare provision in it, the CCG must arrange that provision. And those were previously absolute duties. They had to be complied with at all times. There were no best endeavours defences. This was as good as it gets in social welfare law. But under the Coronavirus Act, which I'll now show you briefly, the Secretary of State was given a power in Schedule 17 to amend various bits of legislation. It's in paragraph 5 of the schedule, so I'll just scroll down. Everyone look away from the slide for a minute, because it'll make you feel sick otherwise. Gosh, this is so long that it's taking time to load. I have to reload it. Here we go. So power to make notices that temporarily remove or relax statutory provisions in England. And we can see that they may, by the Secretary of State, may by notice make provision in relation to England, disapplying or modifying any of the specified bits of law. Importantly, the Secretary of State must state when he does this why he considers that it's appropriate and proportionate in all the circumstances to do so. We'll come back to that in a moment. And this is the table of things the Secretary of State can amend. And we can see one of them is section 19, but he hasn't done that yet. Also, the school transport duties in sections 508A to F of the 96 Act could be amended, but he hasn't done that yet either. But what he has done now is make the notice in relation to section 42 of the Children and Families Act. And we can see that what the Coronavirus Act allows him to do is turn that duty, the absolute duty in section 42, into a reasonable endeavours duty. So section 42 is to be treated as discharged if the person has used reasonable endeavours to discharge the duty. And so we find then the notice itself which is only a 3-page document, and it says very clearly in exercise of the powers under what we just looked at, paragraph 5 of Schedule 17 of the Coronavirus Act, the Secretary of State issues the following notice, and it modifies section 42 so that any duty imposed is to be treated as discharged if the person uses reasonable endeavours. He then gives his reasons as to why he says it's appropriate and proportionate to do this, and he says why he's thought about other options and that it's proportionate, and then makes very clear that the moment this notice covers the period to the 31st of May, but he can issue a further notice, and we'll see whether he chooses to do so. Of course, with the expectation that children might be going back to school in rather larger numbers from the 1st of June, it'll be very important to see if the Secretary of State issues a notice that goes beyond the 31st of May, because that will mean that children will be going back to school without the full protection of their EHC plans, which I would find very concerning. So watch this space. This has been challenged by a parent not a million miles away from you all, I think, and by Polly Sweeney at Rucco and Sweeney Solicitors and myself. We've sent a letter before claim to the Secretary of State challenging the notice and the regulations, saying that they have been issued unlawfully. But of course, until the court decides that issue and agrees with us, they are valid and lawful and must be followed, and the local authorities are entitled to rely on them. There's some very helpful guidance, I'd suggest, which covers both the regulations and the notice. So they've done it in one go. And it says it's applicable to the end of May, of course, because that's when the notice runs to, and will be reviewed before the 1st of June. We get a summary of the notice and of the regulations at the beginning and what they do. And it's intended that this is supposed to help families and parent care forums, amongst others, understand what's going on. So hopefully you would have seen this already, but if not, I'll put the link in the chat now. And what's said is that the government was legislating so as to strike the right balance between the needs of children and young people with SEND and the demands on local authorities and health bodies. And an important message that all other aspects of SEND law remain unchanged. Some key themes in the guidance, including a big section that we're about to see on the importance of co-production with children and young people with SEND and their parents. It's just about to come on to that. Stressing that parent care forums have an important role to gather and feed in parents' views on what can realistically be provided. And also that families need clarity as to what provision will be secured for the child and young person and the reason for any difference from what's is specified in the plan, and when decisions will be made as part of the various processes. So it should all be done in a transparent and open way. There's then some guidance on the notice, and it says helpfully, I'd suggest, but the notice does not absolve local authorities and CCGs of their responsibilities under Section 42. Just means they have to use reasonable endeavours to secure or arrange that provision. And there's an attempt to define what reasonable endeavours means, which is that it means that local authorities and health bodies must consider for each child and young person with an EHC plan what they can reasonably provide in the circumstances during the notice period. And so one of the questions earlier was, well, how about a blanket kind of this is our reasonable endeavours approach? That doesn't work, because the guidance is very clear that it has to be about individual children and families. So this idea of a list of reasonable endeavours, well, no, not really. There can be a list of example reasonable endeavours. We're going to see one of those in a moment, but not one that is mandatory or that limits the things that could be done. And then we have some guidance as to the decision-making process that local authorities should follow, and in deciding what provision must be secured or arranged in discharge of the modified Section 42 duty. These are the things the local authority or the CCG has to consider. First of all, the specific local circumstances, as you'd expect, but also the needs of and specific circumstances affecting the child or young person and their views and their parents' views. And what I think that means is that there's a balancing exercise to be done here. So yes, if things are very bad and difficult locally because of coronavirus, it may not be possible to deliver everything in the plan. But equally, if the child or young person really needs the provision, that increases the emphasis on actually providing it, because that's what would be reasonable in that particular situation. And an important requirement to keep records of the provision that it decides should be secured or arranged. And then that must be confirmed to the parents and young person and kept under review. There's then these questions that should be asked in every case: what, where, how, when, by whom, in terms of differences in the way the provision might be made. And then, as I said, a lengthy list of examples of alternative arrangements, which might be the reasonable endeavours in any particular case. I won't go through that in any detail now. Well worth the read, and you can think about how it might apply to your own case. But these are just examples, and other things could be done. And one of the things I like is this idea of an OT or a physio linking to a child's home and modelling exercises that parents could do with the child. That's an obvious way in which local authorities could support families who are shielding and who may not be allowing anyone into the home, for example. But there's lots of different examples here, some of which I think are quite creative and welcome. And then we get the guidance on EHC needs assessments and plans. And this is where it's very clear that the law is only changed where in a particular case it's not reasonably practical or impractical for them to discharge their duties because of coronavirus. So that's the coronavirus exception. And the modification is to the timing, not to the substance of the duty. So everything still has to be done. It just can be done in a more relaxed time frame. And Annex A, which I won't click on just for reasons of time, but that sets out the detail of all the different changes that have been made to the different steps. Some examples of how this is going to work, some things that have been amended. This is where they recognise the issue in terms of non-binding recommendations from the tribunal, but don't recognise the amendment in terms of actually binding orders, which is slightly concerning. Some examples again of the usual process and what the exception would be. Cases in progress on the 1st of May. This is difficult. So because the SEN EHC process is in lots of different stages, if a stage has been completed by the 1st of May, then of course it's been completed. But if the stage was in progress on the 1st of May, then the suggestion is that the coronavirus exception could apply and there could be a delay to that stage. So again, individual advice is going to be needed. I don't think this issue is particularly well thought through so far. Lots of things that haven't been changed, including section 19 in terms of regards to the wishes and feelings of children and the best possible outcomes provision, of course. Finally, EHC plan must still include all of the required advice and information. So we know there's been no amendment to Regulation 6, which is important. Decisions must continue to be made in accordance with the statutory framework and be based on the individual needs, provision and outcomes for the child or young person. Local authorities must not apply blanket approaches in relation to EHC needs assessments or plan processes and decision making. That's the section to quote if you're worried about a blanket policy being applied in your case. New ways of working are needed in the current exceptional circumstances. You can adapt to your processes, have virtual advisory panels, etc., as you'd expect. Annual reviews, the power to disapply annual reviews hasn't been used, so they must still take place, but the timescales have been relaxed. And there should be focus on those children and young people who are priorities for review, as you'd expect. And they must have already completed this year's required transfer reviews. No change for the statutory deadline for those reviews, and they should be finalised as a priority if they haven't been. Detail about implications for providers, complaints and rights of appeal, unchanged. You can still go to tribunal, as it says here. No change to that, although there is this change to the duty to deal with the orders. Delay in publishing the response to comments on the send offer, and then we get the detail. So I think the key point I would make is that although these are significant changes, it's not like everything has suddenly gone. It's not like we're in the Wild West and there is no longer any duty in relation to SEN and disability law. All that's happened is that the timescales to complete the various steps in the EHC process have been relaxed in most cases. And the duty to secure and arrange the provision has been turned into a reasonable endeavours duty. Now that does mean that for the first time in decades, children don't have the right to educational provision to meet their special educational needs, because you can't have a right to something if there's only a reasonable endeavours duty to do it. And that's obviously hugely significant and I'd say hugely concerning, but it doesn't mean that local authorities can do nothing at all, as the guidance says very clearly. And other entitlements in relation to children's social care, for example, haven't gone away. There's been no amendment to the Section 17 duties in relation to assessment, no amendment to the Section 2 duty in relation to provision. There have been some amendments in relation to children's social care, but they're on things like care planning for looked after children, very important issues, but not going to affect the majority of disabled children. So I would want people to take away from the talk that there is not some kind of wholesale relaxation of the legal scheme and wholesale disapplication of the legal duty. It's some very specific changes which are themselves concerning, but are quite narrow in their effect. A question that's come in about the implications of the current situation for special schools. And if those schools have to delay their reopening, then could a local authority use that to change a name placement? Potentially, I think, yes, they could, because of course, if the child needs to go to school in order to be educated and the school isn't able to reopen, that might be a reason to amend the plan. But if they do amend the plan and the parents aren't happy with that, the parents can appeal to the tribunal and the original plan must remain in force pending the outcome of that appeal. So there is a safeguard there for families not to lose existing placements. I think I've picked up all the questions so far, so I'll now jump back to the slides. Do please ask anything else that comes to mind. That was the Section 42 duty and the modification to it under the notice. In terms of placement then, Section 39 of the Children and Families Act requires the local authorities name whichever school or institution is requested by the parent or the young person, unless it will be unsuitable for the child or young person, which is possible but unlikely. It would mean the parents or the young person have requested an unsuitable school. It would be incompatible with the provision of efficient education for others for the child or young person to attend. Now that is potentially an issue, particularly where the school is, quotes, full. Now, in fact, there is no meaningful way in which schools can be full in this context, because the tribunal can always order them to take one more child. But if they can provide evidence to show that it would be dangerous or otherwise incompatible with the provision of efficient education for other children to have that extra child, then that is an exception, which means that the school should not be named. And then the third and most frequent exception is that it will be incompatible with the efficient use of resources to name that school. And that's usually the case where a parent wants an independent special school or non-maintained special school, and the local authority are putting forward either a maintained mainstream school or a maintained special school or an academy. Because in those cases where there's a state-funded school, the placement cost is treated as being zero because it will be incurred whether or not that particular child goes there. Whereas the cost of the independent setting is taken in full account because that's an additional cost. And so it's almost always significantly more expensive to have the child at the independent school. Now, that doesn't mean you can't get there. What it means usually is that parents have to show that the local authority school is unsuitable, that it won't be able to meet the child's needs, either because it can't deliver a specific aspect of the provision that's in Section F of the plan or otherwise. And if that's accepted either by the local authority or the tribunal, then it won't be an inefficient use of resources to name the school the parents want, because that will be the only school that's suitable. So very often in tribunal appeals, where I'm instructed by parents, what we're trying to do is prove that the local authority school can't meet need, is unsuitable, is inappropriate. And in order to do that, of course, you need evidence, and often that will be in the form of an educational psychologist report or otherwise. So it's a slightly curious position when you go to the tribunal, because you're not really often having to advocate too much about your own school that you want as a family. That may well be accepted to be suitable by the local authority, and the objection will be cost. And so you're having to challenge the suitability of local authorities' preferred school. And importantly, Section 39 applies in full force to independent schools that are on the Secretary of State's approved list under Section 41 of the Act. So Section 9 of the Education Act 1996, which is all about parental preference for school generally, is still relevant, but it's got much more of a residual role here than it did under the old law, where it often came into play. And most of the focus now will be on these tests in Section 39. Got another question coming in. Take that. Lost the chat function. This happens sometimes. I have to come out of. Here we go. So the question is, does Regulation 6 put an equal duty on the contents of all professional reports to provide evidence? As sometimes the EP report can be a lot more detailed than others and refer to more outcomes and provisions than reports provided by other service. The answer is that the weight to be given to any particular evidence is a matter for the local authority. The duty in Regulation 6 is to get the evidence, to get the advice and information, or strictly speaking, it's to request it. And then there is, I think, a concurrent duty on the professional to actually provide it. But if the evidence comes in and some of it's of poor quality, of course, you'd hope the local authority would go back and request better evidence. But if they think, well, in this particular case, for example, the child's needs are primarily communication needs, and so we're going to give particular weight to the views of the speech and language therapist, they're entitled to do that as long as that's a rational decision, or unless you appeal to the tribunal, where the tribunal stands in the shoes of the local authority and decides for itself what it thinks is important. So it's not the case that all the reports have to be given equal weight, but they do all have to be requested, and I'd suggest also actually provided in order to comply with Regulation 6. That's Section 39 and how it works where parents have chosen a particular school. And if the local authority thinks that, that one of these exceptions apply, its duty is to then name another school that it thinks would be appropriate. And then let's think about reviews and reassessments. So this is all dealt with in section 44, which is where we get the requirement for annual reviews of all EHC plans and the specific requirements in phase transfer cases, as the guidance mentioned, which will all be done more quickly. Bear in mind, of course, the duty to do this review is on the local authority. The school or the college is supposed to facilitate it, may have to arrange the meeting and so on, but the actual annual review duty is on the local authority. And there's a key difference between annual reviews and reassessments. Reassessments are a much more thorough reconsideration of the child's needs and the provision required to meet those needs. And they are only really necessary and appropriate where there's been a significant change of circumstances. Some of you might see that my own little one just appeared. Hello, Estelle. And they mean you go back to the beginning and you get the information and advice again. And so much more often than that, it will be a question of asking for an annual review to update and to amend the plan. And then the final slide to mention is, in this section of the talk, is about the local offer, because of course the vast majority of children and young people won't have EHC plans. And the local offer is supposed to be the way in which families understand the provision that's going to be available for all children and young people who have SEN and disabilities in the area, not just those plans. As you can see, it's the requirement to publish information about provision expected to be available within and outside the area, the requirement to consult on that provision, and to publish comments that were made about it. And I would encourage people to use the local offer comment facility to raise concerns about gaps in the local provision, because local authorities have to respond to those comments and have to explain what's being done. Of course, at the moment, the requirement to do so, the timescale for them to do so has been relaxed to some extent through the amendment regulation. So that is the whistle-stop tour through the Children and Families Act and EHC plans. I'll just stop sharing my screen for a moment to see if anyone has any further questions at this stage before I touch briefly on issues around mental capacity and adult social care, which I'm going to talk about in much more detail on Monday for those that are particularly interested in adult issues. Okay, so I'll jump back in to look at those issues in some of the time we've got available, because I have covered the key children's points. So in terms of mental capacity, the important point to bear in mind, and this is why it's relevant to the younger audience as well, is that the Mental Capacity Act applies at the point that a person turns 16, not 18. And so it's definitely relevant to the younger cohort, because you need to be thinking about the way in which decision-making works for young people and a much earlier stage. So the 16th birthday is when the Mental Capacity Act comes into force. There is a particular process in relation to the Children and Families Act and appeals to the tribunal. And in that situation, if the young person lacks capacity to make decisions themselves, the parents automatically become able to do that. A kind of strange mini deputyship process that applies only in relation to those kinds of appeals. So if you are concerned about those issues, you'll need to get advice, because it's expected that 16-year-olds upwards will bring their own appeals if they have capacity to do so. They can obviously ask a parent to be their assistant, their helper. But if they lack capacity to bring the appeal, if they don't understand what's involved, for example, then the parent continues to have those appeal rights, even though the young person has turned 16. In general terms, people may well be aware of the principles in the Mental Capacity Act: the presumption of capacity, the presumption that everyone has the ability to make decisions for themselves. It has to be shown that they don't. The right to make unwise decisions. This can be very difficult for disabled young people. I had a client who wanted to spend all his benefits on the bookies, on the horses. And the question was, well, is that just a really unwise decision? Or does he not understand the consequences of doing that? And that was something that assessment had to consider. And then we get this principle of best interest decision making. But what's really key here is that best interest comes after finding that a person lacks capacity to take a particular decision. And so it can't be used as a way to impose certain standards on disabled young people who may be doing things that are not in their best interest, but that's their choice if they have capacity. And that's going to be very difficult for parents, of course, but that's what the law requires. Of course, there's a grey area between a decision that is capacitous but unwise and a decision that the person doesn't have capacity to make. And that's why expert evidence will be needed in those kinds of difficult cases. So it's really important to emphasize under section 2 of the MCA that capacity is determined in relation to particular decisions at particular times. So we shouldn't have blanket assessments that a person lacks capacity. It should be lacks capacity to make this decision at this time. And so for many disabled young people, their ability to make decisions will improve over time, of course, as they mature, perhaps at a slower rate than others, but that their capacity is increasing. And then we had a definition of what it means to be unable to make a decision, which includes being unable to understand or use or weigh the relevant information. And in section 4 of the Act, we get the detail in relation to best interest decision making. Just 2 key points on that for now. First of all, that the role of the views of the person themselves, P, hugely important and may often be determinative of the answer if that is consistent with the best interest. But of course, the fact they lack capacity means that what they themselves want isn't always going to be determinative of the answer. And also that family members, parents in particular, must be involved in these decisions, unless it would be their case where it would be contrary to these interests because of genuine concerns about abuse or neglect, for example. So best interest decision making shouldn't be used to shut out family members or others that are concerned about young people. There's a general defence in section 5 of the Mental Capacity Act in terms of day-to-day decisions that are made for disabled young people in terms of what they're going to wear or who they're going to see and so on. You don't have to go off to the Court of Protection for those. But where there are difficult decisions, either about whether the person lacks capacity or what's in someone's best interest, that's when the Court of Protection can become involved. And importantly, and this is a very relevant point for parents of young people, the Court of Protection can appoint a deputy, and it can be a deputy either to manage property and affairs or to look after the person's health and welfare. And that deputy can then make the decisions that the person will be able to make themselves if they have capacity to do so. So that's something that's quite attractive to parents. And there's some helpful recent case law that says that it's not any kind of exceptional provision that allows a health and welfare deputy to be appointed. But you should bear in mind that health and welfare deputies can only make the same decisions the person themselves will be able to. So you can't say, well, I'm the deputy, so I'm requiring you to provide the funding for this particular care home because it would be in my son's best interest to go there, or perhaps more, hopefully, a supported living placement. You can only choose between available options. And if you don't like the available options, then the remedy will be judicial review, because the Court of Protection can't force public bodies to do things that they don't want to do. It can only choose between options that are actually available. So deputyship is important, but it's not going to be a cure-all, and people who are interested in that or think it might be appropriate in their case will need to get advice. And then there are these very complicated issues in relation to deprivation of liberty, which I think I'll spend more time on Monday, because there tends to be more of an issue for adults. But I should just mention one point. Children can be unlawfully deprived of their liberty as well. So for example, a child who's in a residential special school or a children's home, or even in their own home, if they're subject to restrictions that go significantly beyond what other children of their age would experience, that can amount to a deprivation of liberty. So if they're not free to leave the home or the place they're living or the place they are, and if they're subject to continuous supervision or control in a way that children of their age typically wouldn't be, then there may well be a deprivation of liberty, which will need to be authorised in order to avoid a breach of their human rights, their right to liberty under Article 5 of the European Convention. And that authorisation will generally need to come from the family court, because you can't get a deprivation of liberty safeguard authorisation for a child. So advice will be needed in those situations. And my concern is that very many disabled young people, children, are deprived of their liberty without proper authorisation at the moment, without it even being recognised. There's an ongoing controversy about the extent to which the parents of a child can consent to arrangements to avoid a deprivation of liberty, because one of the elements of a deprivation of liberty is that there's no valid consent. At the moment, the position is that they can, but when the Supreme Court looked at the question in relation to 16 and 17-year-olds, they said that parents can't consent for that group, and doubted whether they could consent for children as well, but that needs to be resolved on the facts of a real case. So watch this space. But certainly I would be very concerned as a local authority not to just rely on parental consent. If there were controversial issues around deprivation of liberty, that's where individual case advice is going to be needed. And if a child or a young person has been deprived of their liberty unlawfully, they can bring a claim for damages under the Human Rights Act, as well as potentially on other grounds for which legal aid might be available. So it's important to keep these issues in mind, even though they will only be relevant for a relatively small but particularly vulnerable group of disabled children. Just drop out to see if there's any questions that have come in on that. Not on that, but a question about children repeating the school year in the current context. I can certainly see why people think that might be appropriate. I don't think I have any particular legal advice about that. I think that's more of a practice issue and something that parents will need to think about in their own particular case. But I would say, of course, that schools need to keep their reasonable adjustments duties in mind. So you'd hope that requests of that sort will be treated favourably if they're made as a result of the current pandemic. And so just in a few minutes, I'll flag up some points that I'm going to discuss in much more detail on Monday in relation to the CARE Act, which is the law in relation to adult social care. And I'll jump through these slides because I'll deal with them on Monday and just focus in particular on these issues around transition from children's social care to adult social care. So the way you get from children's social care to adult social care now is through a series of assessments for children, parent and other carers of children, and young carers, all of which should be done after the child turns 16, before their 18th birthday, with a view to making it clear whether they're going to be eligible from the age of 16, from the age of 18. And that process is subject to an important easement that I will go through on Monday in detail. But in short, during coronavirus, local authorities don't have to carry out these assessments, and they don't have to comply with this duty in section 66 to continue to provide services during the transition process if they've made a decision to trigger the easements. But very few local authorities so far have done that, and none of them are in the Northwest. Trafford hasn't. They're all in the Midlands, apart from Sunderland and Middlesbrough, who did trigger them and then went back. So at the moment, the CARE Act is supposed to be operating in full in every local area that hasn't triggered the. So you don't have to worry, I'd suggest, too much at the moment about those potential changes. But I'll go through that in much more detail on Monday for those that are particularly interested in the adult position. So if there's anything else I particularly wanted to flag up about the CARE Act now, because I'll just be repeating what I'm going to say on Monday. I think what I'll do before I come to the concluding slide is just come back to see you all and see if you have any particular questions or any other comments that you'd like to make before I wrap up. If there isn't any, sorry, if there's anything I haven't yet covered that you were hoping I was going to cover, please do take the chance to put it in the chat now. We've got a few minutes before we were going to end at the 3:30. Otherwise, I'll let you go and get a cup of tea or go back to looking after children probably more accurately. Yes, someone's pointing out I can't see the slides. Sorry, I think I had a screen share failure at that point as well. I'll make sure the slides are emailed over so they can be sent around to everyone, and you can check out anything you might have missed. I wasn't sharing the screen at the point I thought I was. So advice about support for children returning to primary school. So it's the same as I was saying throughout, I think, that if the child has an EHC plan, then the local authority is going to have to use the reasonable endeavours to get all that provision in place. If they don't have an EHC plan, then the school has to use its best endeavours to secure all the provision the child needs, whether it's without the plan in place, it may not be quite so clear, but that whatever is accepted to be necessary, the school must do its best to provide. So those children who haven't got EHC plans, the duty falls on the school, both under the Children and Families Act, but also under the Equality Act in terms of their reasonable adjustments. Any other questions? Okay, well, in that case, I will show my last slide. I failed to show some of the previous ones. So I think what we've got now in relation to the Children and Families Act and the Care Act, which I'll talk about in more detail on Monday, is a body of law that much better reflects good professional practice. And there's certainly nothing in the legal scheme that stops local authorities or CCG doing what's necessary for disabled children and young people, I'd suggest. What is an issue, and particularly at the moment, is whether there's a duty to do it, because unless there's a specific duty to do it, it may be that in the current context, it just isn't going to get done because of resources. Some of the elements of the new law come with very significant resource implications. For example, securing the provision in the EHC plans, providing carers services under the Care Act, appointing advocates. Other areas are much more about new ways of thinking. So the wellbeing principle under the Care Act, which I'll look at on Monday, or Section 19 and the duty to focus on best possible outcomes and being ambitious for children and young people. They don't themselves require money to be spent to comply with. But if there isn't money available, it may be quite difficult to actually achieve real change for families, as opposed to just some fine words, which the legislation contains. So my last point on the slide is that there's a real opportunity despite the context of cuts. I think that's still right, but we do have to be realistic that with the coronavirus situation, authorities in particular are facing very significant financial pressures. And the front page of The Guardian, I think it was either yesterday or today, talking about 20% cuts. We have to be very concerned about where we will end up after all of this. And the pressure needs to remain on nationally and locally to make sure that disabled children and young people are a priority, as I'd suggested in the beginning of the talk, the law requires. Otherwise, there won't be the resources available to make things real. And we can't have a situation where people can only access their rights each one by one, bringing judicial reviews. That's completely unsustainable. So the opportunity is still there, but there's a threat too, if we're thinking about the SWOT analysis. And the threat is the implications for public finances of coronavirus. And the need, therefore, is just enhanced to make sure that our young people and children and young people maintain sufficient priority. And I'd say the first task for everyone, including the forum, is to put as much pressure on as possible locally, so that the regulations and the notice are only used in the way that the guidance says they should be, i.e. where necessary on a case-by-case basis in terms of the regulations, and that genuinely all reasonable endeavours are used to secure provision. And then secondly, that they're not renewed, because in particular, it's very important that the notice is not renewed at the time when the vast majority of children and young people are going back to school. So I hope working together, you'll be able to support that pressure. And of course, there is the legal case that we're waiting at the moment for an answer to from the Secretary of State to our letter before action, which I think the Secretary of State is providing next week. So watch this space on that. I'll come out of the slides. Oh, just to show you contact details. If you've got a particular question following up from today, you're welcome to email me. If you have just a general, I need a solicitor inquiry, I'll probably send you back the list of solicitors on my blog. So that's Rights and Reality Solicitors. But if you've got a case that particularly picks up any of the things we've discussed today, I may be able to find people that can help. So you are welcome to email me. I do, as some of you will know, tweet about this stuff all the time. So it'd be great to connect with you on Twitter at Steve Broach, and there's the blog address. But rather than going through the blog, it's probably easiest if you just search the phrase Rights and Reality as one word, and then the thing you're interested in particular, the list of solicitors. It's probably more effective than trying to use the internal search engine. I'll just come back out and see if anyone has any further final questions. Anything else anyone wants to ask? Great, thanks for those who are saying thank you. That's very kind. It's been great. Thank you for the questions, which were really good and very much on point. I hope it's been somewhat reassuring, because I think there is a risk that people think that the law has just been thrown out of the window during the pandemic, and it absolutely hasn't been. You know, the amendments are significant, but they are focused. And if something hasn't been changed, then it has to be complied with in exactly the same way as previously. So do keep using any of the law that you've already picked up from my book or elsewhere, to make sure that our families get the rights that they're entitled to. I'll hand back to the forum. Thanks very much for having me, everyone.
Thank you so much, Steve. That was absolutely brilliant. I certainly feel reassured, and I'm sure that our parent carers in our Zoom room feel the same way as well. So as Steve was saying, he's back here again at 1 o'clock on Monday afternoon, looking at the Care Act and the adults side. If you haven't already joined through Eventbrite, then please do. All the details are on our Facebook page. It just goes for me to say thank you so much, Steve. We are so glad to have you on board, and that you're doing such a fantastic, marvellous job championing our children and young people. So thank you once again.
And just to say, in terms of Monday, there'll be some repetition, because of course I've still got to give everyone the basics who didn't join last time. So apologies in advance for that, but there will be plenty of new content as well. So it would be worth joining on Monday if you're interested in the post-18 space. Although there'll be bits that you'll hear again, most of it I hope will be. That's the idea.
Great, that's fantastic. So from us all, we'll say farewell. Stay safe, everybody. Have a really good weekend, and we'll see you all next week. Thanks a lot.
Thank
you. Bye bye.
Bye bye.